Welcome to episode 9 of Sea Lawyer Station. My name is Jose Malari. In California, a single decision can determine whether a young person walks into juvenile court or faces the consequences of the adult system. That decision changes everything. I will be joined today by Richard Arroyo. He is a powerhouse litigator and highly sought after criminal defense attorney in San Diego County, California. If you find value from this episode, please hit the subscribe button. I will greatly appreciate it. Enjoy watching. Attorney Richard Arroyo, welcome to Sea Lawyer Station.
Oh, thank you. Thank you for stopping by.
You're welcome, and thank you for letting me visit you to interview you today. As a token of my appreciation, I would like to give you a box of chocolates.
Oh, well, I appreciate that. I definitely have a sweet tooth, that's for sure.
Good.
Thank you. Appreciate that.
Thank you. You're welcome. And before we start, I'd like to give a shout out to our mutual friend, Attorney Mark Ignacio. Mark, thank you for introducing me to Richard here. And also, thank you for inviting me to your office and interview you last month.
Yeah, Mark's an exceptional estate planning attorney.
Yes,
and
I agree.
He's a referral partner, and I refer all clients and people to him for estate planning.
Richard, you are a member of the California Bar, and your practice area is criminal defense. But I'd like also to mention to our viewers, in case they didn't know, that you are a licensed real estate broker.
That's correct.
So, do you represent buyers or sellers of homes?
Well, I mean, I can represent both buyers and sellers.
Okay.
And I've been a real estate broker for over 25 years and an attorney for over 40 years.
Wow.
I'm pretty old.
Oh, it doesn't look like it though.
Well, appreciate that. You're very
welcome.
nice.
In other words, prospective clients could call you either for criminal defense or about real estate questions.
Yeah, no, absolutely.
Okay.
Absolutely. My primary business is my legal practice, and I do criminal defense, both adults and juveniles. And I have an extensive juvenile court experience and practice, and I do some personal injury as well, but primarily criminal defense.
So both your law office and real estate office are located here in the same spot?
Yeah, that's correct.
For our viewers who may not be familiar with San Diego County, how many miles is this from the Mexico-U.S. border?
It's probably about maybe 10 miles, but you know, this is my office is located in Chula Vista, which is the southern part of San Diego County. And so Chula Vista is the second largest city in the county of San Diego after the city of San Diego.
Regarding your criminal defense career, what inspired you to become a criminal defense attorney?
Well, when I graduated from high school, I went to Kearney High School, and I graduated from high school. I initially wanted to be an air traffic controller because when I was young, my parents would send me to my grandparents in Iowa for the summers, and I was flying by myself, and so I kind of fell in love with flying. So when I graduated from high school, that was my goal, was to become a air traffic controller. So I went to Mesa College for a short period of time and finally realized that the only way to really do it was to join the military, because the military has the best training. And I decided at that time, might be a bit of a mistake, but the military wasn't for me. And then I decided, well, I was going to go to San Diego State. So I went to San Diego State and I majored in finance, in business. And then after that, I had tunnel vision, Jose. It was either I was going to be a doctor, or I was going to be an attorney. And I always enjoyed science, but I was never very good at it in terms of grade-wise. So I thought, well, I'm not even going to try to become a doctor. And then once again, well, I'm going to go to law school. And that's how I ended up going to law school. My father was a parole officer. And people have asked me, is because he was a parole officer, is that why you got into criminal defense? And no, I mean, I really didn't. He got a master's degree after World War II, and he in social work. So then he got a job in Northern California as a counselor in some type of girls' rehabilitation facility, and then he got a job in San Diego as a probation officer. After that, he became a parole officer, and so that's what he was. And so I moved to San Diego with of course, my dad and my mom when I was in 4th grade, in 1963. And I've lived here the entire time, except when I went away to law school at UC Davis for 3 years. So to answer your question, once again, I mean, I had tunnel vision. It was either a doctor, an attorney, and I went to, decided, well, the attorney route was the route I was going to take.
But there are various practice areas of the law. What made you choose criminal defense?
Well, when I first graduated from high school, my dad was ill. So, and I went to UC Davis, which is by Sacramento. So my dad was ill, so I came back to San Diego. I wanted to, because my dad and mom had divorced, so she was in Mexico City. So I came back to San Diego, and basically I was kind of, just kind of spinning my wheels. And then I eventually met somebody that had an office building, and I just opened up my own practice. And one of the first things that I did was start taking court-appointed work, and they happened to be criminal defense work. And back in those days, there wasn't any public defender or alternate public defender. All representations of criminal people that are charged with crimes that needed attorneys was all by private attorneys. So that's how I got involved in that. And then after that, I eventually got more involved with juvenile criminal cases, and I've always maintained, a lot of experience in that area. But that's how I kind of got into it. But, these days, and I tell, young attorneys, once you get your law degree, there's a lot of options that are available for you. You don't have to practice law. You can work for the public defender. You can work for the prosecution. You work for the government. There's a lot of options. But to answer your question, I just kind of fell into criminal defense, and I've always liked it. There's basically 2 types of attorneys, I think. Ones that sit in their office and don't go to court, and ones that do go to court. And I'm one of those that I like to go to court. I think I'm a people person, so I enjoy engaging with prosecutors, judges, and in the real estate, it's kind of the same thing. I mean, you have to be kind of a people person to kind of deal with sellers and buyers and that type of thing. So that's kind of, Jose, how I ended up doing criminal defense.
I know you mentioned a lot about with your parents, your childhood, but could you give us like a brief life story from the day where were you born, where you grew up, and your education and professional experience?
Well, I mean, I'm an only child, and my father was born in Dallas, Texas, and he was Mexican, and my mother was born in Mexico City, and my understanding is she was on vacation in Texas, and that's how she met my dad. So that's the story that I heard, and so they got married. And after that, I grew up in Iowa. My dad's parents were in Iowa, so in Iowa. Once again, I'm an only child. And then after that, we moved to Northern California. My dad got a job in the girls' rehabilitation facility after he got his master's degree in Santa Rosa, which is right north of San Francisco, I believe. And then he got a job in San Diego as a probation officer. So that's how we got here. And after that, I mean, I was always in school. I mean, school was very easy for me. I didn't, have too many problems. And I went to Kerner High School, played football, graduated, and then, of course, it was kind of expected I was going to go to college. And there I went to do a sidetrack for the air traffic controller. But then I went to college, and that's kind of how I got there. But I was born in San Antonio, Texas, and I didn't spend a lot of time there. What I do remember, Jose, is it was hot.
Oh my goodness!
And I remember growing up in Iowa. When you're young, the snow and everything, it was very nice and that type of thing. And that's where I went to the YMCA, and I learned how to play pool. But I don't really remember. Really, when I was in San Diego, I was in 4th grade. So this is kind of really all I know in San Diego.
Yeah. Since you're here, you practice in San Diego. Do you accept clients outside San Diego County?
I really don't. I'll handle clients either on the real estate side or, my legal practice throughout San Diego County. Like, for instance, my office is in Chula Vista, and tomorrow I have a case in El Cajon. It's a child abuse case. By the way, I've done a lot of child abuse cases over the years. So tomorrow I have a case that's in El Cajon. So San Diego has the, judicial branches in Chula Vista, South Bay, El Cajon, Vista, as well as downtown San Diego. So once again, tomorrow I have a case in El Cajon that I'm going to be traveling to. But I do cases throughout San Diego County. Other people have reached out to me about doing a case in Riverside and that. But in order for me to do that, I have to charge accordingly. And I'm really I think my fees are very, very reasonable, and frankly, I will tell that person, you're better off probably finding an attorney that's closer to the courthouse or closer to where you're at, and I can help you find someone that can help you, that can. So to answer your question, I primarily handle both real estate as well as my legal clients throughout San Diego County. Someone asked me recently about a case in El Centro, and I just told that individual, what you're going to need to pay me in order for me to go to El Centro, you're better off letting me try to find an attorney that's already there.
Do you appear in state or federal court or both?
No, my practice is primarily in state court. But I have, over the years, Jose, I've met a lot of people, and I have referral partners that practice in federal court. And some of them are Spanish speaking and some of them aren't. Because I grew up basically speaking English, so Spanish is my second language. But when I started to practice my practice, by necessity, there's a lot of people that like to speak Spanish. Mm-hmm. And I understand just about everything, and I can relay things in Spanish. But when I really want someone to really understand what I'm saying, I'll say it in English. Okay, but I do know attorneys that practice in federal court that speak Spanish and some that don't. So typically, these are attorneys that I've known over the years that I've referred clients to, and they've done a good job for them. So I have like a handful of clients that that practice, or excuse me, attorneys that practice in federal court.
You mentioned about practicing in juvenile court and adult court. I want to start between those two. I want to start with juvenile court. How different are sentencing outcomes between juvenile court and adult court for the same crime?
Well, I think, first of all, you have to understand that if a person allegedly commits a crime and they're under the age of 18, they're in the juvenile justice system. Mm-hmm. If they're over the age of 18, well, they're in the adult system. And someone that's in the juvenile system with a juvenile court case have the same rights as someone that's in an adult court case, but there are definitely differences. And one difference, just being right off the bat, is juvenile court, basically the purpose is to rehabilitate a young person. Mm-hmm. In adult court, it's to punish them. That's how I try to explain it to a young person. In adult court, punish them. But in juvenile court, if a person is taken into custody, they do not have a right to bail out. Okay, in adult court, if someone is arrested, typically they can pay a bail and they can be released. So that's another significant difference. Another difference is in juvenile court, a juvenile does not have a right to a jury trial. Okay, in a juvenile court, if a client tells me, Richard, I didn't do it, then we're going to have a trial, but a judge will decide whether they've committed the crime or not. In adult court, the person's entitled to a jury trial. Okay, and in juvenile court, frankly, to answer your original question, there is no prison. Okay, in adult court, a client is potentially facing going to prison, and I think it's well settled that if a person's brain doesn't fully develop until they're about 26 years old. Okay, so a person who commits a robbery, as a juvenile, is going to be treated much differently than if I committed a robbery at my age. So it's kind of the difference, and that's the way it should be. People that are young are very impulsive, and they do things, that they, if they had a better understanding of life, maybe they would think differently. But to answer your question, people in juvenile court are treated not as harshly as adults.
How does your strategy change when defending a 14-year-old as distinguished from a 34-year-old?
Well, once again, it kind of really depends on their history, because generally when a person is charged with a crime, what's important is, do they have a criminal history? And a 14-year-old, hopefully, they don't have an extensive criminal history, whereas for someone who might be 34 years old might have quite a few things. So that's one factor that's very, very important, is their criminal history. And then also, it depends on what they're charged with doing. Whatever crime they're charged with, with committing. But generally speaking, I try to personalize all my clients, and these judges and these prosecutors, they see these individuals, whether it's in the adult system, the juvenile system, they see these individuals coming through, and I try to basically personalize my client, whether it's an adult or a juvenile, so that so that the prosecutor maybe can't identify with them, but can understand, well, maybe this person is different than some of the other individuals that they see all the time.
California allows many juvenile records to be sealed. Is sealing automatic, or does it still require legal work?
Well, if it's a juvenile court case, a record can be sealed. If it's an adult matter, it cannot be sealed, but it can be expunged. So an expungement basically is the process. It's the best thing that a person can do as an adult as far as a criminal record is concerned. It's called an expungement. In juvenile court, records can be sealed, and there's certain circumstances. It depends on what the offense is. If it's a certain offense, for instance, a robbery, generally speaking, will not be automatically sealed. It can be at a later time. Generally, the person has to reach the age of 18, and then they can ask the court to seal their record at once they reach 18. There's other charges, for instance, stealing a car. That's a certain offense that if a person can successfully complete probation, at the end in juvenile court, the judge would make a determination that the person successfully completed probation, and then at that point, because it's stealing a car, it can be automatically sealed. And as far as the juvenile is concerned, that's the best possible thing that could possibly be done. Be at the end of a case is that their case is sealed.
Can sealed records still impact immigration or federal background checks?
Well, I think they're still discoverable. And for instance, if I'm a juvenile and I have my record is sealed and I want to become a police officer, my understanding is that even though the record's been sealed, a law enforcement agency will have access to it, and it might show up on a criminal record check, whether it's federal or state. That's my understanding.
Okay.
But from a practical standpoint, when you're representing a juvenile, sealing is the best we can do.
When an officer catches a minor committing a crime, they can warn, cite, or detain them. With that much discretion on the street level, how can we ensure that decisions are not influenced by bias, neighborhood, or the minor's background?
Well, I think what's important, particularly in the juvenile area, of course, is that once, for instance, let's assume someone goes to Target and steals something, right? Then Target security will basically detain them, and they'll talk to them, and then typically they will call, for instance, Chula Vista Police Department. So the police officer arrives. Then a police officer has certain discretion. They can basically call the parents, and if the parents come and seem to be responsible, that type of thing, a police officer can just release them, just kind of with a slap on the wrist, so to speak. But law enforcement agencies, a lot of them have what's called diversion programs. In other words, in that example, a police officer might determine, well, we're not going to send the arrest report to a prosecutor, but we're going to handle it within the Chula Vista Police Department, for instance, or the National City Police Department, where basically the person's going to agree to do certain things. And maybe some community service work, maybe take an anti-theft class, that type of thing. And as far as the police diversion program, as long as they do everything you're supposed to do and demonstrate they've done everything, then that's the end of it. More serious offenses, a robbery or anything involving gangs or violence, typically police officers will take them to East Mesa where they're detained. But they do have certain discretion. But in the juvenile area, I kind of hate to see it, but the apple doesn't fall far from the tree, And so a lot of these kids, they're having issues, that's not necessarily caused by them. But anyway, I don't want to go down that rabbit hole too much. But generally speaking, if a police officer feels that the parents are taking responsibility, aren't trying to make excuses for their child, whatever the situation might be, they're more inclined to have some leniency from law enforcement.
Are certain communities more likely to see detentions instead of warnings?
I don't think so. I'd like to think, and I have a lot of respect for law enforcement and our first responders and that type of thing, and I'd like to think that all police officers, they're putting their lives at risk. And even though I'm a criminal defense attorney, I have a lot of respect for a police officer. My dad was a parole officer, but I don't think so. I'd like to think that every police officer, does their job, and regardless of race, regardless of sexual orientation, that they're going to do the right thing. So I can't really say from a statistical standpoint whether someone that's has a situation in Chula Vista is different than than Center City or that type of thing. I'm optimistic.
Is there a meaningful review of the police officer's decision to detain or warning?
Well, it can be, because generally speaking, there's an incident, and then someone calls law enforcement, and then law enforcement will get involved. And in order for a police officer to arrest somebody, juvenile or adult, he or she needs probable cause to think that they've committed a crime. And probable cause is it's more likely than not, is like 51% that the person committed the crime. If the police officer determines it's like 45%, well, then they don't have probable cause to arrest the person. Okay? And once they arrest the person, well, they take him to jail or take him to juvenile hall, whatever the case may be. But the decision is ultimately up to the prosecutor, what they're going to charge them with. And I've had cases before where a police officer, I just had a recent case, a domestic violence case, where the individual was arrested, taken to jail, an adult case, taken to jail for domestic violence, and he was a felony. He was accused of injuring his wife, and so I got retained, and I was able to persuade the district attorney's office that it was an isolated incident and not to file charges against him. And that's ultimately what happened. They decided, that it was an isolated incident. Counseling was involved, and there was children involved as well. CPS got involved and didn't remove the children. Just basically, they were a professional couple, and they need some help. So that's just an example of the prosecutor rejecting the case. But Jose, crimes that involve more violence, it was gang related, any type of violence, those cases are very seldom rejected. Now, the prosecutor might charge the person with the same charges for which they were arrested, and sometimes it's different.
How many types of hearings are in the juvenile court system?
Well, there's. Let me backtrack for a second.
Okay.
Now, because when when a prosecutor is going to accept or reject a case, once again, the police officer needs probable cause to arrest.
Okay.
A prosecutor needs to believe that they can prove the charges beyond a reasonable doubt. So I kind of look at it, probable cause, I try to explain it. Probable cause is like 51%, 52%. Beyond a reasonable doubt is like 90%. So a police officer might have probable cause to arrest somebody for stealing a car, but if the facts aren't quite that strong, a prosecutor might decide, well, I don't think I have a 90% probability of convincing a jury that the person committed, so they might reject the case. So it's a different form of proof. And I think you asked me about hearings in juvenile court.
Yes.
Well, once again, a person who's a juvenile and gets detained, they take them to East Mesa. That's where the juvenile detention center is. They have a right to have a detention hearing within 48 hours. So at that detention hearing, a judge is going to determine, are they going to be released or are they going to remain detained while the juvenile court case goes through the system. And typically, for that purpose of that hearing, Jose, the judge has to assume the charges are true. But that's another thing that both adults and juveniles have in common is we mentioned earlier, is their rights. I mean, they have a right to present evidence. They have a right to have an attorney, so once again, the judge, for purposes of the detention, has to assume the charge is true. And then based on the family, based on any school records that can be shown, a judge will make that determination. They're going to be detained, and the more serious the conduct, the crime, the more likely they're going to be detained. But the judge can exercise his or her discretion and release them with an ankle bracelet, like home supervision. That's a possibility as well. But once a police officer takes a person to the juvenile detention facility, they can either keep them or let them go. Okay, that's happened before. But generally speaking, the more serious the crime, the more likely they're going to be detained. So that's the detention hearing. After the detention hearing, the next hearing is called a readiness conference. And this is kind of similar in adult courts as well. You have your arraignment in adult court, which is your first hearing, and then you have a readiness conference. So basically in adult and juvenile systems, there's usually a readiness conference. And Jose, the purpose of the readiness conference is for the judge and the prosecutor and the defense attorneys to talk about the case. Sometimes it can be resolved, sometimes it can't. So generally at the readiness conference, you either tell the judge, we've reached a plea agreement, a settlement that both the accused person and the prosecutor are okay with, or we tell the judge, no, we can't reach a deal, then we want to go to trial. So that's at the readiness conference hearing. And after that, you have the trial. and in juvenile court in front of a judge, in adult court in front of a jury. And then the jury decides, or the judge decides, did they commit the crime, yes or no. After that, in adult court, you have a sentencing where the judge is going to decide what's the sentence going to be. Are they going to get probation, or are they going to be sent to state prison? And in juvenile court, it's called a disposition hearing. So it's a different language. And at that disposition hearing in juvenile court, a probation officer will write a report for the judge, and then the judge is going to decide in the juvenile court system what is the best way to rehabilitate this person. Okay? Does the person need to be continued detained into like a camp program, that type of thing? Or can the person be released back to the home to see how that goes? And generally speaking, if a person hasn't gotten in trouble before, it's more likely that the judge and the probation officer might recommend that they be released to go back to the home on probation. So those are basically, the choices.
Questions on a couple of the hearings. First is the detention hearings. A child can be locked up and face a detention hearing
Within 48 hours.
48 hours, okay.
Yeah.
In your experience, is that enough time for a meaningful defense?
It depends. I mean, if the person reaches out to me, if someone calls me, Jose, that their child has been arrested for stealing a car, okay, and they're in juvenile hall. If they reach out to me early enough, then I can tell them, okay, well, this is what I need you to do. I need you to get any school records, okay? I need you to, because generally speaking, my experience has been that the young people that don't get in trouble, they're going to school every day, they're behaving when they're in school, and they're getting passing grades. They're involved in sporting activities. They're involved with church. Okay, they're involved in the community. They're just not sitting at home playing video games. All right, and so in that example, if it's a good student, give me all the records. Good student, give me character references. There might be people, for instance, if my child was detained and my next door neighbor is a police officer, okay, or a commander in the Navy or something like that, and that police officer or that person who's a responsible person, and they, quote unquote, can write a letter. I've known Jose for 10 years. He walks my dog, and I trust him. Then that will help any character references for someone that that the court will find credible, as opposed to an aunt that just says, "Oh, but he's a perfect child." That doesn't help a lot. And also any certificates that they might have had. For instance, if the person's involved in sports, then if I could get a letter from like a coach, saying that I've known so and so for such and such, that type of thing will be important. So with that type of information, if I get the case soon enough, then the likelihood of convincing a judge to give the parents a chance, or give the young person a chance to go home is important. Also, if there's supervision at home. Now, if I can argue that that the child will be, because if the child is allowed to go home, let's say on home supervision, they still have to go to school. And if I can convince the judge that mother's going to take the child to school, and father and pick the child up, then that there's 24 hours supervision. And assuming that the crime doesn't have to do with school, taking a weapon to school, selling drugs at school, getting in a fight with school, that type of thing, then that's another important factor if there's good supervision. And also, the parent comes to court, and they're dressed in shorts and a tank top. That doesn't make a good impression. But to answer your question, the sooner I can get a case, whether it's an adult case or a juvenile court case, the better the out, because I got control of it. And the likelihood of a better outcome is increased.
You mentioned at the detention hearing, the court must assume that the petition is true.
Yes.
Isn't that a fundamental tension with the presumption of innocence?
It is. But generally speaking, that's the only exception. Generally speaking, you or I, if we're accused of a crime, we're presumed innocent. And we don't have to prove anything. And until we enter a guilty plea in adult court, or until I admit I committed an offense in juvenile court, or we have a trial in front of a jury or in front of a judge, we are presumed innocent. Okay, so I could walk out of my office now and get arrested for robbery, all right? Am I going to resist? No, but they're going to take me away. But then, once again, I'm presumed innocent. But in juvenile court, in terms of the detention hearing, that's really the only exception where that is not the case. And in juvenile court, a judge has to presume that the charges are true. And you need to explain that to the parents. They probably won't ask me that about the presumption of innocence, but I do make it quite clear at a detention hearing that that the judge, just for purposes of the detention hearing, to decide. And the judge at the detention hearing isn't deciding whether they committed the crime or not. just in deciding can society be protected if the person's allowed to go home. That's really the key in the detention. Protecting the public and protecting the child, that type of thing.
Does that standard then make it more difficult for a minor to get released?
It is. It does. It does. Yeah, it does.
Okay. Now the other hearing is, I think it's called fitness or waiver hearing?
Well, there are fitness hearings, and the law has changed. But before the law was changed, the district attorney, if they decided that a juvenile committed a criminal act that was really, really bad, really, really serious, they could immediately just file the case in adult court as opposed to juvenile court. But the law was changed a few years ago. So now, certain criteria, and I have a recent case, I have a case tomorrow, where the individual is charged with attempted murder, okay? And so he's already detained. And the district attorney has decided, through their chief, that they want to move him, or they want a judge to order him to be transferred to adult court. Okay, and so what we're doing, we're going to have what's called a fitness hearing. Mm-hmm. Okay, and at that hearing, a judge is going to decide basically, is the person going to remain in juvenile court, or is the person going to be transferred to adult court? And in the law, as far as fitness hearings, recently changed as well. What's really important is, in the judge making that determination, is the minor amenable to being rehabilitated in the juvenile court system? Okay, that's the key, amenable. And for instance, if the person doesn't have any prior record, but committed a very serious offense, doesn't have a prior record, then that will help. And also, when I have a client now that's detained, and I told him that this is a very serious, they want to transfer him to juvenile court. I told him this is a very situation. We're going to put this case out maybe 5 or 6 months. And during that period of time, while you're detained, I want you to demonstrate to the judge and to the prosecutor that you can stay out of trouble. Okay, you're not going to be getting in fights. You're not going to be disrespecting staff, probation officers that run juvenile hall, that type of thing. But those are fitness hearings. The law has changed in that area.
Okay, thank you.
And those are very serious. I mean, and the district attorney, in all fairness, only tries to have an individual transfer to the adult court if it's a very serious offense and they have basically history.
Mm-hmm.
They've been on juvenile court for probation. They keep on violating their probation. So, they don't ask. I forgot. Another point is what they're charged with. A person has to be over the age of 16 in order to be able to transfer to adult court. So that's age 16. You've probably heard of strike offenses as well. Mm-hmm. So in juvenile court, if the person is under the age of 16, regardless of what the charge is, it's not a strike offense. Okay. If they're over the age of 16, then for instance, a robbery is a strike offense, plus the district attorney, because they're over the age of 16 and it's a robbery, which is a pretty criminal, it's a serious felony, can ask the judge to have a hearing and send them to adult court.
I know you mentioned like getting records, school records, recommendation, all that. If a 15-year-old in California is arrested tonight, what must their parents do immediately?
Well, if they're arrested, the question is, are they going to be detained, or are they going to, or is police going to, basically take them to the police station, call the parents, and then release them? Okay. So, so it really kind of depends what they're going to do. But if they're going to be detained, then I think the parents need to reach out.
Mm-hmm.
They can, when they go to court, everybody needs an attorney when they're charged with a criminal offense. They can either have a public defender represent them, or they can hire a private attorney like myself. But they definitely need representation. So, I guess, depending if it's an adult or a child, there's not much a parent can do other than if they get the child released, for sure, for them not to get involved in any more trouble. That's for sure.
Mm-hmm. Now I'm going to shift to the criminal defense career.
Okay.
What skills are most important for young lawyers entering criminal defense practice?
Well, once again, like I said, there's some attorneys that just kind of stay in their office, and there are other attorneys that go to court. And I think one thing is communication and writing skills. Writing skills are very important. My major in college was finance, worthless. It's worthless. But now, some some individuals that want to become attorneys, they do criminal justice. But I think the skills is communication. Oral skills are very, very important, and also writing skills are very, very important. And learning how to type. I mean, I never learned how to type in high school, so now I do like this my entire career. I type like this. Thank God for for spell check. But I mean, that's something that's very, very important. And even I think even psychology. An undergraduate degree in psychology. How people think. That type of thing would also be helpful. Psychology, I think, Jose, can help you in life generally. Dealing with people. Why are people acting that way and that type of thing. But having good writing skills, communication skills, and computer skills as well would be another thing that's very, very important. But I think those are skills that I would recommend to any young person that's considering becoming an attorney.
How can someone choose the right criminal defense attorney?
Well, I mean, I get a lot of calls from people finding me on the internet and that type of thing because I have a lot of Google reviews, 5-star, and I tell them you need an attorney, and some people just for some reason will not choose a public defender. They think, maybe they have prior experiences, but, public defenders, they do this type of work day in and day out, and they're good attorneys, but some people just don't want a public defender. And my overall impression is that when a person has a public defender, the communication isn't really there. And there's lack of communication, and, then I think individuals just sour on the public defender. In the juvenile court case, it's it's similar, where if I'm representing a juvenile person, then my client is the juvenile person, not the parents. So if the juvenile person, anybody that I'm representing who's charged with a crime, anything they tell me is in confidence. I can't relay that without their permission to anybody else. Okay. So in the juvenile area, typically a young person like, yeah, you can speak to my parents about it. So then it's important for me to be able to share the information with their parent, because the child is eventually going to get released and they're going to be living with the parent, not with me. And I've had parents tell me, oh, my child doesn't have a problem with drugs, or my child's not a gang member. Yes, they are. Okay. So, that's important, to be able to share that information, with the parents, and because I need them to help me. Let me interrupt you for a second. I apologize, because you asked me about the attorney. So, I've had a lot of clients, that basically they'll call an attorney, and the attorney right away tells them, this is what I'm going to charge you, and they don't even listen to the client. And I think, to me, Jose, it's not all about money, and because people that basically reach out to me, they have situations, and they're generally not good situations. So you have to listen. You have to listen to them, and I try to keep them focused. But you have to have some compassion for them. So I think an attorney that basically, that listens to them, that it's not all about the money. I think that's an important factor. In fact, I had a client once retain me to represent her, where she reached out several attorneys, and the attorneys kind of cut her off, but I listened to her, and I never talk about money until the end, because they usually ask me, well, what would you charge to represent me? Well, then I tell them. But when they initially call me, I'm talking to them about their situation. Well, tell me what happened, and I try to keep them focused so they don't ramble off on something, and so I can have a better idea of what their case, because ultimately, if they ask me what I'm going to charge them, well, depending on what they told me, that's going to be that's going to be my fee. I kind of adjust my fee. But kind of finishing up about choosing an attorney. Because there's attorneys out there that have a lot more experience than I do in different areas, and I try to kind of stay in my lane. And and over the years, even like clients that I refer to attorneys in federal court, I know these individuals that they kind of think things the same way that I do.
What separates a good defense attorney from a great one?
Well, that's a tough question. I certainly don't consider myself a great attorney, but I think it's experience. Attorneys that they go to trial a lot. And at this point in time, I'm 72 years old, so I don't need a lot of stress in my life. But if it's someone, it's a very serious offense, then you need an attorney that has a lot of trial experience. So if I have a case, then I might refer the case to someone that has the experience. But you see trials on TV and that type of stuff. So they kind of, it's not all the way how it pans out in a trial, but someone that's that's articulate is important. Someone that basically knows the rules of evidence is important. But there's some very outstanding attorneys in San Diego, and we know who they are.
Can a criminal defendant face both state and federal prosecution for the same offense?
Well, for the same situation, okay? I mean, I had a client once that basically he had a girlfriend and she was selling oxycodone, okay? And so he was kind of bringing the clients to her, and the oxycodone was it was laced with fentanyl, okay? So 2 or 3 people died. So they were prosecuting him in state court, and I was representing him in state court. But what happened was they dismissed the cases in state court in order to prosecute him in federal court, where, quote, they have the bigger hammer. Okay, so to answer your question, yes, there are certain cases, that can be in federal court as well as state court. For instance, anything coming across the border, whether it's undocumented people or bringing drugs across, those technically, because it involved the border, I believe can be in federal court, but sometimes they just do it in state court instead.
What should someone do if they are pulled over or questioned by police?
Well, what they need to do is they need to cooperate. Okay, they need not to make the situation worse. So, I mean, answering the police officer's questions. I mean, that's my advice: is just to cooperate. You can ask. What happened, and there's a lot of videos on the internet that people look at, and there's something like a sovereign citizen. I amuse myself by looking at those once in a while. But I think generally speaking, my advice to anybody that's pulled over by a police officer is comply with what they're asking you to do. For instance, police officer pulls you over, and initially he's just going to give you a ticket for speeding or that type of thing. If you start giving him a hard time, then your chances of getting a warning are not very likely. So I guess that's really what my advice is. But for instance, if someone wants to search my car, even if I know that there's nothing in my car, if some police officer wanted to search my car, I'd probably let him do it. Okay, but generally speaking, that's an example where you can say, no, I'm not going to consent to you to search my car. If I just wanted to assert my rights, even though I know that there's nothing in there, I can do that. Then, then there's other things that they can do to try to get permission, even though I said no to search my car. But from a practical standpoint, okay, search my car, and get it over with and let me leave. But I think generally speaking, follow law enforcement. They tell you to put your hands on do it. Don't make things more difficult than they already can be.
What happens in the first 24 to 48 hours after someone is arrested?
Well, if it's an adult, they're arrested. They have to be, the district attorney generally has to file charges within 48 hours. So if I have someone that's been arrested in an adult case, and let's assume their bail is $100,000, so they have to put maybe 8% with my bail bondage, and then 8% of 100,000 is 8,000, so it's quite a bit of money. So and some people, when they get arrested, they want their loved ones out right away. All right, but sometimes I tell them, well, just leave them where they are. This is an adult case. Leave them where they're at, and within 48 hours, either they're going to be released because charges weren't filed against them, or they're going to go in front of the judge, and the judge might release the person without having to pay bail. So they end up saving themselves, in that example, $8,000, and the judge might release them. An adult court case might release them, like with supervised OR, where basically they don't have to pay anything. So that's another possibility. But a lot of times loved ones, we get them out right away, and then that money is, well, you kind of. But at least I explain to the client that that's a possibility. Where you don't have to pay the $8,000, and then we can get them out once again with some information about what they do, that type of thing. Because the whole purpose of bail generally is just to ensure that the person is going to come back to court. Okay, once the more serious the offense, the higher the bail.
Have you ever represented someone who was wrongly accused? And if so, how was that experience like?
Well, wrongfully accused, that's kind of hard to say, but if a person, is accused of stealing a car, okay, and they said, I never stole the car, Well, that type of person is not going to plead guilty to stealing a car. And under those circumstances, we're going to go to trial. But the prosecutor is not going to charge them with stealing the car unless there's some evidence. But I mean, all I can do when a client is making a determination, are they going to accept responsibility, take a deal, or if they want to go to trial, the decision's up to them. But generally speaking, the prosecutor will not file charges against somebody unless they believe 90% likelihood that they committed a crime. So they might have fingerprint evidence, they might have DNA evidence, they might have a video. I tell young people in particular, I mean, you can't even scratch your nose these days without being recorded. Everybody has a Ring camera. I have a camera, not in here, but I have a camera somewhere. And, so, and some of these kids, I mean, you might have 3 kids, they'll go beat some kid up. One kid is recording it on their cell phone while the other 2 are beating them up, and then they put it on social media, and these police officers, I mean, they're very savvy, I mean, they get the social media and, they get a lot of evidence, but I mean, that's kind of the thing. When I was growing up, we'll say, we didn't have cell phones, we didn't have the internet, we didn't even have typewriter, word processor, so things have really changed.
How often do innocent people take deals just to avoid risk?
It depends on what the risk is. Okay. Because if you're looking at going to prison for an extended period of time, a person might plead guilty to an offense that they really didn't do. And sometimes that happens. So it's a matter of risk. I mean, I've had cases that I've gone to trial that I thought I was going to lose, that I won. And I've had cases that I thought I had a good chance of winning that I've lost. You just never know as far as a jury is concerned. I mean, there are individuals like you and me. I mean, I would never get picked for a jury because I'm a criminal defense attorney, but I support law enforcement. So, I mean, I'd be inclined to believe a police officer. But anyway, so, you just never know what's going to happen at a trial.
How do you defend someone who you believe is guilty?
Well, if someone tells me, Jose, I stole the car, but I'm not going to plead guilty, okay? Well, that's okay. I mean, we're presumed innocent, okay? So in that example, we could go to trial and we could force the prosecutor to prove that he stole the car. I can't let the person testify, I didn't steal the car because he's already told me that he stole the car, okay? So I can't allow him to testify falsely. But once again, it's the presumption of innocence, all right? Richard, I stole the car, but I want them to prove it. Okay. Well, then if the prosecutor can't prove it, well then he's not found guilty, and he certainly hasn't entered a guilty plea for the judge, and that's an example of a person that did it, but he's not going to suffer any consequence because of it.
Is justice different for people who can afford private attorneys?
Well, that's a tough question. I think in terms of resources that are available, because sometimes a case needs DNA analysis. Sometimes it needs extensive investigation. Sometimes it needs fingerprint evidence. So when a person has resources, they have the money to pay for these expert witnesses and that type of thing. Whereas if a public defender is representing someone, I mean, they have resources as well. So it really kind of depends on the case. I mean, some of these expert witnesses, like DNA in particular, I mean, I don't really know much about DNA other than, it's almost as good as fingerprints evidence, but probably better. But, so the more resources the person has, the more likely that they can do the attorney can do a thorough evaluation of all the evidence, and sometimes a better outcome will come along.
Do media narratives affect juries?
I think to a certain degree, but I mean, I know, for instance, in juvenile court, generally speaking, those proceedings are confidential. Okay, so the media isn't allowed to go in, and other people that are there aren't allowed to go in. But in certain circumstances, when there's like a high-profile case, media can ask the judge to allow for them to come in and to record what's going on. But those are very serious offenses. But I mean, that's why there's something that's called like a change in venue, where someone commits a crime and it's all over the media. And generally speaking, I think people think, Jose, if this person's charged with a crime, they did it. And when there's a lot of media exposure, Bob got arrested for this type of crime, and and everybody, oh, Bob did it, but that isn't necessarily the case. But you have to be kind of careful with the media.
Is there a case that still keeps you up at night?
No, not really. Actually, one time I had a civil case, where I was representing someone that was involved in a fatality and accident, and it was a civil case. And I remember once I was vacationing in Cabo, and I kept on thinking about the case. But no, not really. I mean, I've been doing this such a period of time. I just had a recent case this morning where it was a juvenile court case, and the parents were, really, they were being very, very difficult. But I had a good conversation with them over the weekend, and so it worked out nice. But it worked out the way it should have, because I had certain advice for this young person. The parents, they were, well, self-defense, this and that, but that worked out. Okay. So, but to answer your question, no, not really.
Do some police officers lie on the stand?
Oh, it's hard to say. I think, like the movies, where they catch them lying. I don't think that's generally the case. They might try to stretch the truth a little bit, and they might make mistakes. But once again, I support law enforcement, and I'd like to think that police officers do not lie on the stand. They might stretch the truth, or if they really don't know an answer, they might say something that, kind of helps the prosecutor's case, maybe, but I'm optimistic that police officers do not intentionally lie. Although there might be some, but I don't think so.
What is qualified immunity? Does it protect bad actors?
Well, I'm not that familiar with qualified immunity, but sometimes when prosecutors are going after a certain individual, they basically allow another person to have immunity so that they can testify against the other person. It's kind of like President Trump, what's going down in Iran. Okay, he's telling the Republican Guard to lay down their arms and they'll get immunity. Okay, that's kind of the same idea that they're not going to be prosecuted, they're not going to be killed, but they need to lay down their arms. But that's kind of the same thing. Sometimes law enforcement has to grant an immunity from prosecution for the less guilty person, or the person that's not, maybe not the cartel leader or something like that. So there's a time and place for some grant of immunity, and that really doesn't, in my practice, doesn't come up too often. But there's different types of immunity. So you got me there, Jose. I'm not quite sure what that means, but there's a time and place for all that stuff.
How do you decide whether to negotiate a deal or go to trial?
It really depends on the strength of the evidence, because sometimes when I get a case, how is it possible that they are charging my client with this crime? Okay, well, it really depends on what the evidence is. Okay, and once again, even if there's weakness in the evidence, where the prosecutor might not be able to convince a judge or a jury beyond reasonable doubt, then prosecutors will negotiate with you, because they understand that our case isn't as strong as we thought it might be. And sometimes good investigation by the criminal defense attorney's investigator, and I've had cases like that where police officers thought they identified this person. No, it was the wrong person. So, and the prosecutor, to their credit, admitted, yes, the police officer made a mistake, and they dismissed the charges against my client. But investigation is crucial, and in making that decision, once again, the decision is up to the client. Okay, they're going to have to decide, but I try to lay everything out for them so that they understand, well, this is the evidence against you, whether it's witnesses, the testimony, whether it's video, whether it's DNA, whether it's whatever the case may be. And ultimately, they decide. And all I tell them, once again, is I've had cases, Jose, that I thought I was going to win, that I've lost, and vice versa.
Okay, thank you.
And I like to think that judges are fair. They well, at least in juvenile court cases, they try to do their best.
What is the most aggressive tactic you have used in court?
Well, I don't know about aggressiveness, but questioning a witness is a skill. It's a skill that you develop over time, because as a general rule, if it's your witness, you need to prepare the witness so that they know what to expect. But typically, if it's a witness for the prosecution, whether it's a police officer or it's a citizen that observes something, then you have to know what you're going to be asking them, and you have to be very careful with any questions you might ask them. So I don't know if that's aggressive or not, but generally I've found, we all have our own styles, and there's certain attorneys that are, get all excited, this and that, and I'm not one of those. I'm more kind of a, I would say mellow, but I mean, I kind of notch it down a little bit back. So I wouldn't say that I'm aggressive in court, although there have been times when I've been evaluating a witness that, that I got little, I don't know if upset's the right word, but, there's something, wasn't right. So, I mean, but I think generally speaking, I don't get very aggressive in court.
What role does technology play in modern criminal cases?
Well, it's changed a lot. I mean, these days, there's videos, and I had a case once where a client was accused of murdering somebody, and it was a gang-related incident, and I was kind of, by myself, but I mean, the prosecutor had an assistant, and they had all these photographs, and they had, a big screen TV, and they were kind of doing that, and, that's the thing about the district attorney's office, they have a lot of resources. Okay, and they've got technical people that can do the videos and this type of thing. Mm-hmm. So, and the judges have come, the courts generally have come a long ways to kind of permitting that type of thing. But, technology, particularly of visual aids are, is pretty, nowadays you don't have any charts or anything like that. Everything's on a video. You don't need to have a chart, generally speaking.
If you could change one thing about the criminal justice system tomorrow, what would it be? And who would fight you on it?
Well, that's a tough question. I mean, I think sometimes prosecutors, depending on what their background is, they get very focused on everybody's guilty, don't give them a break. Whereas in juvenile court cases, I mean, they're young people. They've made mistakes. I mean, I'm 72. I'm still making mistakes. So I think maybe getting more, and this might apply to judges as well, because a lot of judges are former prosecutors, But I think, although there's more criminal defense attorneys that are being appointed as judges, but kind of trying to really become neutral, and leave those biases behind, I think is a step in the right direction. But I mean, it's tough. I mean, I can't even imagine, myself being a judge, just trying, because I have my own personality, mm-hmm. and I have my own views on different things. But ultimately, like when you're trying to pick a jury, I mean, you want a person that has no biases. That's ultimately you want. Like a DUI case, as far as a defense attorney, you want a juror who drinks, a juror who drinks and drives, a juror who's never been arrested for a DUI, a juror who's never, that had someone, killed by a drunk driver, that type of stuff. And as a prosecutor, you want anybody that is just the opposite. But anyway, trials are fun. It's kind of like TV to a certain extent. I mean, you're trying to persuade a jury, and and in trial, whether it's in front of a judge or a jury, you want the jury to identify with you and with your client. That's why if a jury trial, I mean, I try to personalize my client. I'll touch my client, and make sure my client doesn't, act out if something happens, that type of thing. So I try to, if the jury will somehow, identify with me, that they might identify with my client as well. Life's too short, okay. and I found that, as I've gotten older, my priorities have changed. As far as my financial situation is, it is what it is. Mm-hmm. I mean, I'm never going to have a lot of money and, this and that, but as you know, I mean, you're still a young man, but our priorities change. Mm-hmm. What's more important to me are my animals. I love animals. Mm-hmm. Okay, and the people that have agreed to share their lives with me, and mm-hmm. you're one of them now. What you're doing for me. We all have expiration dates. Yeah. And life's too short. That's the same way with fees. I mean, my fees are reasonable, and I just try to do my best to help people. Because once again, I was saying, when people come to me, they're have problems, mm-hmm. So it's not as if, I just sold my house, I have $100,000, I want to invest it. Okay, well, that's a happy thing, but anyway.
For potential clients among our viewers, how may they contact you, and do you have any message for them?
Well, I mean, basically, everybody, Richard Arroyo, I mean, ChatGPT is a beautiful thing. And I've had clients that basically just looking for an attorney, and that's how they find me. But and I had a client recently, and I represented him when he was 15 years old, and now he's 37, and he wants to do certain things. But just Richard Arroyo, and then I just come up, or criminal defense attorney Chula Vista, or whatever. So it's very easy, to find me, and I think the important thing is when you have a criminal situation, speak to somebody. Once again, like I told you before, it's not all about the money, and I've gotten a lot of pleasure, I guess, maybe that's the right word, but helping people that that I cannot help. I mean, they say something, that you can tell about the character you can tell the character of a person by how they treat people that can do nothing for them. And I mean, at times, Jose, I'll take the shirt off my back for people. I mean, at this point in time, I mean, I just want to try to help people as best I can, and I try my best. That's all I can do. I'm certainly not perfect.
Me neither. So, if you find value from this episode, please hit the subscribe button. Thank you for watching, and I'll see you in the next episode. Richard,
Thank you
for the interview.
Okay, thank you for giving me the time.